been introduced to the idea of what law is. So the next step is to think about what kinds of law are there if we're going to understand at a deeper level what law is and where it comes from. So there's many different classification systems out there. These aren't all necessarily the same taxonomy, or they're not the same system. They're different ways of thinking about law depending upon what we're trying to do. So a lot of this section is introducing us to terminology. I do understand it can be confusing, but it's really important that you understand how it can be used differently if we're going to be involved in business. And I'll try and pick that up as we go through. Why is this important to business? It is, and these terms actually have specific meanings in law, and that's why we need to go through them and to understand why they are. The second thing that we're going to do is have a little bit of history. I think we need to understand history to really fully appreciate how the system works, why it is the way it is, where it's come from. That helps us anticipate where the law is going to so that we can run our businesses better. So I understand there's a fair bit of content, but stick with it. Have a think about where possible confusions might lie and go back over that stuff so that you get a solid understanding at this stage. The first thing we need to think about is what is actually regulated by law. So traditionally, there's been two key areas. The first area is public and the second area is private. Okay, so private law is really about the law between individuals, and the state isn't involved. All the state tries to do is to ensure that the rights of the individuals are upheld. In contrast, public law is about the nature of the relationship between the state, and I'm even going to use the word citizen here, right, rather than an individual. So it's a different kind of law. It's about the relationship between the state and the citizen. And underneath each of these areas of law, public and private, you can see a whole series of different topics of law. So criminal law is a kind of public law. It's public law. Why? Because the state prosecutes you, right? The state says you're not allowed to assault someone, okay? And then it is the one that actually prosecutes you, not the person who was assaulted. Constitutional law is about what respective powers do governments have, say the state government versus the federal government. Administrative law deals really with the application of law by the government. Is the government applying the law the right way? And of course, tax, I'm sure you all understand about tax and how its revenue and how that's going to apply. So these are all about the nature of the relationship between the citizen and the state. In contrast, private law is about individual to individual relationships. Clearly, contract law is about where there's an agreement between individuals. Tort law is where you do a wrong to someone or a purported wrong to someone. How does that get settled? Tort law. Now notice an actual act could be both public and private law. So if I were to hit you, okay, well, the first thing that we find is that that's a criminal act, right? So the state could take me to court under criminal provisions, but it also is a tort, and you could sue me for damages that I've caused to you by hitting you. Okay, so it's not so much the act, it's the nature of this relationship that becomes important. So just to reiterate, public law, relationship between the citizen and the state. Private law, relationships between people within the community. And here we have a bit of explanation of each of these core areas. It is worth you understanding what is the law that's dealt with in these areas. So, administrative law, administrative activities of the government. Constitutional law, the relationship between the arms of government and the government and its citizens. Tort, a remedy for those harmed by the acts or omissions of another. Contract, law regulating contracts. Intellectual property, copyright, trademarks, those kinds of things. Okay. Now, unfortunately for us, and I really want us to get this in our head, right? We can have public law and private law. But we can also think about law differently. We can also think about law as criminal law and civil law. Now, I've tried to draw them in two different boxes, right? Because it's not the same classification system. You'll remember from previously that criminal law here, right, it is a form of, it is public law. But under this classification system, civil law, right, that is both public and private. So they're not mutually exclusive. Then we also find we can look at law and we can call it case law, and we can call it statute. And within case law, we can say that there is common law and equity. So those two do go together. Okay. So what's a classification system to help us think about this? So let's think about this one by one. Criminal law is about, as you would imagine, criminal offences and the penalties. The state prosecutes people, and we also have this different standard of proof. Okay, so it's not the burden. The burden is on the prosecution, but the standard that's required is beyond a reasonable doubt. So are you as sure as you can be? Is there no other reasonable explanation other than the person did it? In contrast, civil action is where people are claiming to be harmed but aren't done so by the state. In these areas, what we have is something called a balance of probabilities as the test, right? So the test here is it more likely than not? Okay. Notice that's a really different standard that's required under criminal law versus civil law. There are other differences, but that's one way of understanding why we need to understand these terminologies, right? You will need to have a different level of evidence if it's a criminal matter versus a civil matter. That can be important in business because there are both criminal actions. Breaching directors' duties can be a criminal act or a civil matter. The other classification that we had there is case law and statute. We'll get into this a little bit deeper, but in essence, because we have a common law system, okay, because we have a common law system, the basis and genesis of our legal system is what judges said. It's case law and the role of precedent. We'll come to that later. That precedent is how we develop the common law. So it's the law that's made by judges through the doctrine of precedent. In our topics, contract law is an area that has a lot of case law. I mean, there's a lot of statute that supplements it now, but the original basis of a contract, what is an offer, what is an acceptance, etc., is about the doctrine of precedent and the application of case law. In contrast, statute is a law that Parliament makes, an act of Parliament. So we're going to do consumer protection in week 10 as an example of that. So we have these two sources of law, and that's why we classify law according to these two sources. Notice again, this is an entirely different classification system. Statute law, case law. Really importantly, if we have a conflict, so just say the judges say one thing in case law, and then Parliament comes along and writes a statute, which one wins? Statute will prevail. Right? Provided it's within the power of the Parliament, the statute prevails. Why? The basic idea here is that Parliament are the people who we've elected. So when they make a law, it's reflecting the will of the people. Judges, in contrast, right, they're not elected. So if they're thinking differently to Parliament, who should society follow? And the idea is, well, we should really follow those people who are elected. So we go with statute law trumping case law in the cases of a conflict. At the risk of getting very confusing, I think it's really important to understand the potential uses of this word common law. In one sense, common law means the system of law in a country. So if we go back to the great empires in history, this is where these classification systems come from and the differences come from. This is a particularly English or Anglo approach, and it has to do with how law developed in Britain. The civil law system has far more to do with continental Europe and Roman law or Napoleon, the Napoleonic Code, if you're interested in that kind of gear. Okay, we have civil law systems. A common law system has judge-made law and precedent at its core. Okay. Civil law is about being a written code by Parliament, and that is the law. The systems operate very differently. Okay, this is an inquisitorial system, and we'll probably come to some of those differences. Now, within a common law system, like in Britain and Australia, we know that we also have common law, which is judgments, right? But we also have statute. So you can see it's a bit confusing already because we have a kind of common law within the common law system, but it gets even more confusing. Within judge-made law, there are various types of law. And guess what one of them's called? You've got it, common law. There were other things, maritime law might have been a section, and the other one that we concentrate on is equity. Okay. So we are in the common law system within which there is statute and common law, which is judge-made law. That judge-made law or common law has different areas of law, which were basically the courts, right? The courts of chancery had equity. So these different courts would have different areas of law. One of those areas was common law. So if you see a question asking you about common law, you need to be able to work out what aspect of common law are they talking about here, right? Are they talking about the system versus some other countries? Are they talking about judge-made law versus statute? Or are they talking about a kind of law, common law versus equity? So common law, in terms of the third level here, refers to case law that came from the common law courts. Over time, it was one of the first areas, right? It became rigid and inflexible. So all the people started going to the monarch at the time saying, hey, help us out. These laws are too rigid. We want to appeal to you. So what's the monarch do? Set up a different court, the court of chancery, right? The monarch wants to go hunting, having a good time, having a few drinks. They don't want to be listening to all these people complaining. So what do? They set up another court. That court becomes focused on equity or fairness. Okay? So this is where the area of equity in law comes from this particular court. In Australia and in the Anglo system now throughout the world, these areas aren't separate anymore, they're fused, but they have a different genesis. They also have different outcomes. Under common law, our key remedy is damages, right? Money to put you back into the position you would have been in before the act or omission of the other occurred. In equity, sometimes money isn't enough, right? Sometimes what you need to do is to stop people doing something, which is an injunction, or make them do something, right? So if someone's going to knock down a heritage listed building, once they've knocked that building down, there is no amount of money that can rebuild it, right? You can make a model, but you can't get the building back. Okay. So what do we have? We have these other remedies, and they come through equity rather than common law. Okay, remember the three senses of common law. Remember the differences between equity and common law here. As I mentioned, while these developed as separate branches, most judges now can apply the appropriate one that they want to. We don't have equity in common law. It only applies to civil disputes, but not all of them. Okay, there are some rules around when it applies and when it doesn't. That's a fair whack of content about topics of law. Hopefully you'll take some time, get an understanding of what those concepts mean. Once we do, we can pop off to think about the actual sources of law and where law comes from.